Good afternoon, everyone. I see that we have some people that are still kind of filing in. I apologize, it looked like we had a little tiny technical glitch, but we are back underway now. So I wanted to say hello and welcome you all to our panel discussion. And thank you so much to our viewers and our speakers for joining us today. So my name is Lisa Welch. I work within the Indiana Civil Rights Commission as the director of the Native American Indian Affairs Commission, and I'm going to be your moderator today. So ICRC is very pleased to present our panel of experts, and today we're going to be having a conversation with them about rights and resources for people with disabilities as it pertains to housing, accessibility, and accommodation. So during our formal discussion, if you have any questions for our speakers, please enter them into the Q&A tab on Teams, and you can find that by clicking on the speech bubble icon with the question mark inside, and then we'll be happy to share those with the panel at the end. So right now we have some slides introducing today's participants. So speakers, when you see your name and your smiling face, please go ahead and introduce yourself and tell us about your organization and your role, and then we will begin with the panel questions.
I'm muted. Hi, my name is Tracy Richardson. I am with the Indiana Civil Rights Commission. Obviously, we are the enforcement agency for the civil rights laws, as well as the Fair Housing Act for the state of Indiana. I serve as the ADR director. I am the director of the Alternative Dispute Resolution and Compliance Department, which is basically our mediation department. When a complaint comes into our agency, once we've determined jurisdiction and it's started to go through the investigation process, and perhaps even if there's been a reasonable cause finding under fair housing, and it is in litigation, there's a possibility to mediate that complaint. It is desirable within our commission and our agency to mediate complaints, so we provide those services free of charge to both respondents as well as complainants. We have a fairly good success rate. And so that's pretty much what I do. I've been with the state for about it'll be 3 years in November, but also served at the Office of Attorney General for about 8 years.
Great, thank you so much, Tracy. And up next. Tammy, welcome. If you wouldn't mind introducing yourself, talking a bit about your organization and your role, that would be great.
I had to figure out how to unmute. Well, I've done it now for all of you so that none of you will look as silly as I just did. My name is Tammy Thummel. I'm the CEO at accessABILITY, which is a Center for Independent Living. We support our peers with disabilities in Marion and the 7 surrounding counties. Independent living works a little bit different in that we work to increase independence of people with disabilities because we ourselves are people with disabilities. So I use she, her pronouns. I identify as a person with a disability. My disability is invisible, which means I sit with an enormous amount of privilege. I can choose to disclose or not disclose as I wish. I am always privileged to be part of these conversations, and with some of the illustrious fellows on this panel, I feel a little humbled. So I'm excited to be here. Thank you.
Great, thank you so much. Welcome, Tammy.
Hi, everyone. My name is Prashan. I'm the legal director for Indiana Disability Rights. IDR is the designated protection and advocacy system for the state of Indiana. Our mission is to uphold, promote, and advance the rights of individuals with disabilities through empowerment and advocacy to achieve a more equitable society. So we provide no-cost legal representation to people with disabilities in a variety of disability rights related areas, including fair housing. IDR provides a spectrum of services from technical assistance and support to helping oneself advocate, to assisting with requests for reasonable accommodations and modifications, all the way to federal litigation if needed. I am also president of the Fair Housing Center of Central Indiana Board of Directors. So I have another kind of connection to fair housing there, and I'm happy to be here.
Great, thank you. Thank you and welcome, Tom. All right, I think we are ready to move forward with our questions. This first question goes out to all of our panelists, so I want everyone to kind of weigh in eventually, but I'll kick it to someone to just kind of pick on them to get us started so that we don't talk over each other or we don't have that virtual meeting silence before accidentally talking all over each other. So the question is, how can we work to educate and spread awareness to landlords and property managers about disabilities, people with disabilities, accessibilities, and accommodations? Tammy, wouldn't you mind taking this first question, please? Just to
I wouldn't mind at all. So one of the things that we've been doing is reaching out to landlords and property developers to give them information on the desirability of people with disabilities as tenants. The data shows that a person who finds an accessible and affordable unit stays 6 times longer than the average renter in the Indianapolis market. We work very hard to provide supports and services to the landlord and or the development company in a positive and encouraging manner. Sometimes it's necessary to go in with the heavy hand of the law, and we need to do that when that's appropriate, but it's also possible to come in and show them how small changes can make a very big difference. One of the things we think that could make a huge difference is finding more opportunities for all of us to talk to all of them, to have the opportunity, now that COVID numbers are going down, knocking on wood, to increase that communication rate. And I think that, again, they certainly know when they've messed up, but we also need to find a way to show that really simple changes can make a huge difference. And also addressing the issues of gentrification and how to keep subsidies rolling long past their expiration date.
Right. Thank you. Yeah, I like that you're talking about having a conversation in an ongoing format that is not just a punitive kind of dynamic. So thank you. Anybody else want to weigh in?
I didn't mean to suggest anyone was being punitive. There's a role for that. Sure. I just realized how that might have sounded. Sorry.
No, that's okay. No, I thought that brought up a really good point. Does anyone else have any thoughts that they wanted to share on this first question?
Well, go ahead, Tracy.
Well, I was going to say, and not really trying to be punitive, but because I did want to speak about education, I do agree with Tammy. I think education is really important. Obviously, the Indiana Civil Rights Commission has an external affairs department that does a lot of education. They do trainings, they participate in community events, they do outreach with respect to medium. I know they do radio. They've done, again, lots of trainings, television, social media, websites, online. We, of course, have our website. But with respect to punitive, I do think it's important that the laws do have some teeth. And we really work hard here to ensure that we are an informal agency, that we apply them uniformly and fairly. And so we really try to take complaints in and ensure that if the Indiana state law says something is not appropriate or something has to be done, there should be consequences for that. Of course, again, I'm over the ADR department, so we do attempt to settle. We're not always looking to be punitive. And when we settle, we actually educate. A majority of our settlements, obviously in housing, have affirmative relief in the public interest, and a lot of that consists of training. So education is really important, but I think consistency in the law can be helpful too, because then you kind of have that word of mouth where it's being spread, you can't do this, you can't do that. And the more it's consistent, the more important it becomes to the provider. as well as, important to the provider to train employees, particularly in areas of housing, tenants, relationships, property managers, even real estate, residential real estate employees, that, these kinds of things are off limits. These are the kind of things we can't engage in. It's going to be important. Then they begin to see it as more important on taking the onus or the responsibility upon themselves to go out and get that education. So the education piece is important, but unfortunately that punitive piece, being out there and being real, is important too.
Sure. And I think I might have misspoken and maybe brought that term out too early, but I'm glad that we're talking about it now. And I love the point that you made, that of course we want everyone to be prioritizing these things, but we see our role in how we can offer clarity, and that clarity will encourage that prioritization. So that's wonderful. Tom, did you have some thoughts to share on this first question?
Yeah, sure. I'll just add, and I agree with both kind of the importance of organizations trying to get out to landlords and property owners and educating them on their rights. But I think, in the role of being a landlord and a property manager, there's an obligation for them to know what laws apply. And unfortunately, oftentimes, especially in this realm, it's only after a fair housing violation where landlords and property managers and their staff will recognize the need for fair housing training and then obtain it at that point, unfortunately. But there are always, a number of opportunities for landlords and property managers to receive the training they need to kind of better educate themselves. I mean, Tracy mentioned ICRC's External Affairs. Fair Housing Center puts on an annual conference every April. It's a perfect opportunity, a one-day conference to kind of get a rundown on what fair housing laws apply. But it ultimately is on the landlords and the property managers to proactively obtain that knowledge, unfortunately. Importantly, though, I do want to mention that, we're talking about educating the landlords and property managers. It's very important to also ensure that the tenants and the people with disabilities understand their fair housing rights. HUD estimates that 99% of fair housing violations go unreported every year, and a large reason for that is because people don't know their rights, and they don't know, that it's important to that they have an opportunity to, get an accommodation or get a modification. So it's really important that obviously not only the landlords and property managers know what laws apply, but also that those tenants know what rights they have living in those settings.
Wow. Okay. Yeah, that statistic shows quite a bit of room for improvement, I guess, when it comes to the education and public awareness for people with disabilities. So thank you for sharing that. I think that's actually kind of a segue into this next question that again is for the whole panel. But Tom, why don't we go ahead? I'll pick on you first with this next one, and kind of as a follow-up to what you were saying. So obviously, awareness of what those rights are is a barrier in the area of housing. What other kinds of barriers are encountered by people with disabilities, and how do we break down those barriers? And I guess that is in addition to issues around accommodation and accessibility and things like that.
Yeah, sure. This is a great question. I think the number one thing is probably the accessibility of the units and the availability of accessible units. That's kind of something that everyone in the community kind of battles with when there are not enough. The Fair Housing Act requires units to be designed and constructed accessibly, a certain number of them. Unfortunately, even though that's been a requirement for 30 years, we still see complexes being constructed and designed inaccessibly. And when that happens, then you're taking those accessible units off of the availability of, for people who need them. So, it kind of goes toward, again, knowing their rights, knowing accommodations are available, knowing modifications are available, especially in those situations where it's not an accessible unit, but we could make some modifications that make it usable to that individual. I think another barrier that we don't often think about is source of income as it relates to people with disabilities. Source of income isn't an independent protected class, but there is some overlay with people with disabilities. For instance, we've seen recipients of Social Security being denied housing because of that status. That comes in the context usually of a landlord requiring employment, for instance. Employment really isn't what the landlord should be requiring. It should be ensuring the individual has the resources to pay for the housing, and oftentimes Social Security is adequate for that. So that's a kind of a barrier that is often seen that people don't really make the connection with, the Fair Housing Act, but it is absolutely a fair housing situation when someone's denied housing because of their, recipient's status of Social Security.
That's something to consider, definitely. Thank you. Anyone else have anything to add?
I'd like to talk about, we're working with a developer at the moment, and one of the things that in looking at their website, they don't post the floor plans of the accessible units. And we've to them, often they say, well, just drive down to look at it. And we have to discuss the barriers for that. Simply posting a floor plan of the unit and with some distance. So for example, if we know the space between the counters will not allow that individual to negotiate, they can eliminate something. And it's a great, I think it's a great advertising source. We have these accessible units. Listing a unit as accessible when all the other resources in the complex aren't accessible. For example, the laundry room isn't, the rec room isn't, the swimming pool isn't, or the sidewalk and parking arrangement are such that someone would have to travel an inordinate amount of distance in the cold, wet, nasty weather to get to their unit. Those are some of the things that don't often occur to a landlord, that actually it could be a good marketing to put that floor plan out there. Paying for multiple application fees. This is something a lot of our consumers reach out to us for assistance with. They're very expensive. And in a perfect world, it's kind of like the universal grant application we all hoped a nonprofit would arrive. But it would be really nice if there was a way that one application fee for a period of time would cover multiple rental opportunities.
Okay.
And obviously, as Tom talked about, the income multipliers. When you're asking me 2, 3, and 4 times unit, again, that's doable for a lot of people, but not for most people.
Great. Okay. Thank you. Tracy, do you have anything that you wanted to add?
Yeah, I was kind of just going to talk about both things. I think it kind of wraps up in the biggest barrier being, I don't like to use the word ignorance, but the lack of knowledge on the part of providers and the implicit bias when it comes to dealing with individuals with disabilities. They talked about actual physical barriers like doorknobs or cabinets being able to reach, or doors being wide enough, sidewalks that go into the door, and whether there's a giant bump that, a wheelchair might have to maneuver to get accessible, and how quick can you get to the elevator. Besides the physical barriers, you just often have providers that just have not, again, made it their business to be educated on what the requirements are for any type of modifications, structural modifications that may be needed so that they're accessible, the percentage of units that should be accessible, those. And even again, the requirements when it comes to making applications, because we actually get complaints of people against policies where, they said I can't apply because I was using my Social Security check, and they told me that if I ever am late, they're not going to be able to go after my Social Security income, that type of thing. So a lot of lack of knowledge of the Fair Housing Act as it relates to disability rights is kind of the biggest barrier to individuals with disabilities. Even when it comes to requests for reasonable modifications and accommodations, I've heard providers say things, well, I told them I don't give reasonable accommodations. And it's like, you don't have the right not to give a reasonable accommodation. That's not your call, but people don't understand that. So
Right.
yeah, just that's a huge barrier in and of itself, is not knowing the law, because so many violations can occur, whether it's on the accommodation or the modification side. And sometimes it's not that people, and they will say this, I did not intend to discriminate. I'm not trying to be discriminatory. They just don't understand they're not following the law.
Sure, sure. And that is the intention versus impact, isn't it?
Yes.
Well, in that vein, one of the things that we've done is try to encourage those property owners to view a modification as a unit of improvement. They have the right to request that the tenant pay to have that modification removed. And if they've, for some reason, have lowered the cabinets to a height that is not the average, that might make sense. But most modifications are things that could stay. If there's a grab bar in the shower, it's just a place for me to hang my washcloth or my shampoo. It doesn't detract in any way from the unit's rentability in the future. And so that's another way we're trying to, because paying for it is one thing, but it's really painful to have to pay to remove it.
If I could just add to that, so the only there are situations where the tenant may be required to remove, but it would only be required if it does affect the livability of the next tenant. So those grab bars, the widening of doorways, they would have to pay to install, they wouldn't have to pay to remove. But yeah, 100% right. I think that's a great tact, is to encourage the marketability of those units, that these are accessible features that have been added now through a reasonable modification process, so therefore the next tenant could benefit from them.
Wonderful, thank you. I think our next question is actually for Tracy. Yes, and you'd spoken briefly actually when we were having during the last question about reasonable accommodation, reasonable modification, and people saying, well, I don't do that. But sort of continuing on of your mention of that, can you explain the difference between those terms and kind of give an example of those?
They're both protected under our Indiana civil rights laws. I'm sorry, they're in our Fair Housing Act. But the accommodation is more an adjustment to perhaps a policy, like the housing provider that says, I need employment. If you're going to make an application for one of my units, you have to show proof of employment. Well, if I am living on perhaps Social Security, disability, and perhaps some other forms of income, I should be able to show that I am a qualified individual with a disability, that I could make those payments reasonably. And so they may need an accommodation to that particular policy. When it comes to a modification request, again, it's just as we discussed, someone may need to actually widen a door because their wheelchair doesn't quite fit through the standard door width that's in most of the units, or they may need to lower a cabinet or open it up underneath so that a wheelchair can be accessible underneath it. They may need different types of doorknobs. They may need the kind that you can just pull down as opposed to the round ball that you can grab. There are a variety of modifications that may be needed, but they kind of both go through the same type of analysis. They make that request and have that discussion. And of course, our laws talk about some things, particularly in common areas, that should be accessible already, and how many accessible units you should have. So there's some law that kind of guides what should already be in place for a housing provider. But when you make an accommodation request, you're kind of making a request from a specific policy. Of course, your policy in and of itself shouldn't be discriminatory. So you may have a policy that's not necessarily discriminatory, and there still may be a need for a request, an accommodation request based on a particular disability. The courts have pretty much said that the primary responsibility is that if that request is found to be reasonable, or what's most important initially is that there is an engagement and a discussion. And so they kind of call it the interactive process under our civil rights law. It's not technically the interactive process, but it's the same thing. It's a back and forth conversation that a housing provider has the responsibility to engage in, to make a determination as to what is a reasonable way to ameliorate that disabling condition that that individual is having the challenge with. And again, if it's reasonable, which means it's not going to create an undue administrative or financial burden, it won't create a direct threat to other tenants, or it doesn't change the purpose of the business of the provider, then it will more than likely be found to be reasonable if you can make that nexus that that accommodation request ameliorates that disabling condition and allows that individual to use and enjoy your housing. So I know that's kind of a legal kind of analysis. Those are the actual terms that the court uses, kind of in just real time. If it's not going to be something that's going to be financially or administratively onerous for a provider, and it is based on an actual qualified with an individual's disabling conditions need, then more than likely it's going to be, I won't say that, but it's likely it would be found to be reasonable. So it's just really important that you have that conversation. You don't want to run from that conversation. You don't want to say things like, I don't grant accommodations, I don't grant modifications, that's not my policy. You have a requirement to do that. And also we try to let providers know there's no requirement that it's on paper or that it's on your specific form. We also have providers that say things like, well, no, they didn't make an accommodation request because they didn't place it on my form. So
Okay.
Hopefully that was helpful.
Yes, very robust answer. Thank you so much for that. Much appreciated. Excuse me. I think next we are probably going to switch gears just a little bit. So for Tammy, can you talk to us about the Centers for Independent Living? What are those, and how does your organization collaborate with these entities?
So Centers for Independent Living are created under federal regulation, and my agency has been in operation for 35 years. We are required to be people with disabilities. So by law, 50% or more of staff and board must be people with disabilities. So our staff, we're about 75%, and our board 65%. So the idea is that as peers, we understand at a level that is different from other agencies. We are the only agency that is required to be people with disabilities. We provide those supports and services to anyone who identifies as a person with disability in our catchment area, which again is Marion County and the 7 surrounding counties. Excuse me. Someone asked me once, well, what is it that you do? And I said, I really wish that was simple to answer. So we have 5 core services: information, referral, exactly what it sounds like. Someone calls and says, my rights have been violated, who should we talk to? There's also independent living skills, everything from cooking, budgeting, understanding what they want to do next and how to get there. Project management and planning, self and systems advocacy, and that's very much what you're seeing today. We're talking about the systems and how we work within them, but on an individual level, we would work with that tenant, for example, to do what Tracy was talking about, inform them of their rights, encourage them, often participate along with them in a conversation with their landlord, perhaps. Peer support, literally, we get it. We understand your fears, we understand your frustrations, and there's almost always someone we can connect you to that understands it from your particular disability's viewpoint. And then lastly, we do something called transition and diversion, which, because they're governmental terms, mean 12 different things. Transition is either removing adults from institutions such as nursing homes or group homes back into the community, or for young folk, it is students exiting the educational system and helping them go to their next level, whether that's additional schooling or into the workforce. And we do that in a variety of ways with different programs. For example, we have an inclusive employment program that helps people understand how to work with Voc Rehab and other resources. Domestic violence and sexual assault departments, because sadly, people with disabilities are inordinately impacted by violence in their lives. If you are a woman with a disability, you have an 80% chance in your lifetime of being a victim, a survivor of these issues. And if you have an intellectual and developmental disability, the odds are that you will have been impacted 8 or more times in your life. It's a very disgusting set of statistics. We also have VIBE, which is visually impaired blind experience. We can provide accessible technology and other tools to people who are impacted by their vision. We work at the behest of the consumer, what they want. Think of us as the cheerleaders, helping someone accomplish their goals to increase their independence the way they see it. So it's not for us to determine what independence means for a person, it's for us to be there with them. And what we hope to do is to spider web within the community to connect people to the right resources. We don't need to know all and be all, and even if we wanted to, we couldn't. But we want to be good partners in the community and expand services and supports for our peers.
Okay, thank you. Thank you. I know you just said you can't be all things to all people, but it does sound like you make a valiant attempt. So
it's interesting. Again, I truly did have a colleague just say, well, what is it we do? And the example I would give, in our world, there's a lot of conversation around the difference between empowerment and enablement. And the example I would give you is today, I might need to have my hand held, literally help to make the phone call. And maybe even I just want to listen to my advocate talk to someone. And in a month, I might just need encouragement to make the call. A year later, I'm off and running and I'm down at the State House testifying. So it changes within someone's life, within the issues that they're experiencing. And again, we try to provide the services that someone needs and to be good partners in the community.
Sure. That's wonderful. Thank you for explaining the breadth of everything that that you are there to walk alongside people for. Some of those things are really hard to hear, but it's wonderful that you're there to meet people where they are and provide so much of what they need in so many different situations. So thank you so much for sharing that. Our next question, I haven't picked on Tom in a while, so if you could walk us through the importance of advocacy and empowerment, as we were just talking about, of individuals with disabilities.
Sure, yeah, this goes toward, a lot of things that Tammy just talked about. From our standpoint, it is true for anyone encountering a legal matter that they can be very complicated situations. So offering that expertise and providing advocacy to anyone in those situations is important. We want to ensure that people's rights are recognized and upheld. As I mentioned earlier, in fair housing, that could be representing an individual and directly working with the housing provider and the landlord about if it's a denial of housing or an accommodation or modification request. We can directly provide that advocacy for that individual. If that advocacy fails, then we can provide, further legal advocacy to the individual if it comes to a legal proceeding, or that ultimately includes federal court if it comes to that. Hopefully we're able to resolve those issues prior to that, but we can provide that advocacy in, the full spectrum. As important though, and kind of going toward, what Tammy mentioned, is educating, individuals on their own rights and providing whatever technical assistance can be provided to empower individuals so that they can appropriately self-advocate. In the fair housing context, someone may not even know that they have a right to a reasonable accommodation, for instance. They don't know what it is, how to request it, what to request. Educating them on that process, providing them assistance on how to, for instance, draft a request letter, what to include, what to expect as a response, what the landlord can request and can't request and how to move forward in that process, not only to enforce their rights without the need for advocacy, but also I think that it's important that in future situations, having been able to self-advocate and now knowing their rights, they can do that on their own in the future. So, I think they're both equally important, but, ensuring that individuals know their rights and understand what they can and can't do, and what landlords can and can't do in these situations is really, really key to ensuring that they are empowered to kind of enforce their rights on their own. And, if that's not possible, or they attempt to self-advocate and are unsuccessful, then, we're absolutely here to provide that advocacy and work directly. Unfortunately, society is that oftentimes, once a attorney signs a letter, then change happens. I wish that wasn't true, but if self-advocacy fails, then we have those attorneys to sign those letters and provide that advocacy to hopefully affect the change that needs to happen.
Sure. Yeah, sometimes that is what it takes. But yeah, again, I'm hearing recurring themes of advocacy, but also empowerment. Right. Empowerment and education first. It sounds like where we need to start to really keep on moving the needle. Thank you very much for that. Our next question was actually for one of our panelists who's supposed to be here today, and unfortunately he's been having technical issues and wasn't able to join us. I don't want to put anybody on the spot, but if anyone on our panel would like to offer their thoughts on the differences between an emotional support animal and a service animal, and maybe talk about the responsibilities of housing providers and what questions, looks like what questions can and cannot be asked, or what kind of documentation might be required. If anybody has anything to share, again, don't want to put anyone on the spot, but I would love to hear your thoughts if you have them.
I can jump in if anybody doesn't want it.
Take it away.
Sure. So there's a difference between, most people may be familiar with the term service animal under the Americans with Disabilities Act, and that law covers individuals accessing places of public accommodation. So your stores, your restaurants, your theaters, things like that. The Fair Housing Act obviously oversees the housing of an individual, and so the animals allowed under the ADA and under the Fair Housing Act are a little different. The ADA, first of all, provides a nice definition. It is a dog that is individually trained to do work or perform tasks. I will note there is an exception that allows miniature horses in situations as well, but it specifically says under the ADA that emotional support, well-being, or comfort is not an ADA service animal. Under the Fair Housing, it is extraordinarily much broader than that. First of all, they don't even define what animal it needs to be, so it doesn't specify dog or miniature horse or anything like that. But the guidance from HUD states that an animal that's permitted as a reasonable accommodation is one that works, provides assistance, or performs tasks for the benefit of the person with disability, or explicitly provides emotional support that alleviates one or more identified symptoms of the disability. So the Fair Housing Act specifically allows for an emotional support animal. Quote unquote emotional support animal, quote unquote service animal are kind of maybe terms of art, or maybe even legal terms in things, but the Fair Housing Act does not necessarily define either or. So basically, if an individual with a disability requires an animal of some sort that meets this guidance definition, then that animal should be allowed as a reasonable accommodation, no matter if it's a no pets building, no pets complex, etc. It should be allowed as long as it's works, provides assistance, and performs tasks, or it doesn't provide emotional support that alleviates one or more symptoms. So, from this context, there's a difference in quote service animal under the ADA and quote animal allowed under the Fair Housing Act, because that would under the Fair Housing Act include an ESA or an emotional support animal. But as far as kind of the responsibilities for landlords, it goes back to a regular reasonable accommodation request. What can they ask for? What can't they ask for? Does the individual have a disability? Is this request needed because of the disability? As mentioned earlier, is there that nexus? That's kind of the legal term. Is there the relationship between the disability and their needs and the request for the accommodation? And the same processes happens for animals as well. People think it's a little more complicated, but it's really not. It's the same thing as a reasonable accommodation request. You're just processing as the need for the animal as opposed to a need for, you know, an exception to a different kind of policy or something like that.
Okay.
Tom, it's
Oh.
Tammy. I had a question. There is a perception, and we've certainly heard it from some land owners, property owners, that service animal has become, what's the word I'm looking for, misused. Is that something, how do you address that, or is that something you see is actually happening in housing issues?
Unfortunately, I think it's happening in all situations, from the ADA and the fair housing situation. I think people who either don't have a disability or have a disability but not a disability related need for the animal are trying to utilize animals and get allowance for animals. I think the important aspect, I mean, there's not a good solution yet, but whatever solution does come up, I think the important aspect is that you're not limiting or watering down the rights of people with disabilities who actually do need those animals. So, you know, really the process from our standpoint at IDR is, you know, if there's a request, then we look at it first and, you know, we go through the process that the landlord's required to go through under the Fair Housing Act and say, okay, does this person have a disability? Is there a disability related need for this animal? And then, you know, that's enough for us to make the case under the Fair Housing Act. You know, the same kind of a related consideration of the ADA. We recently had a case where an animal was, a service animal was denied at a grocery store. So the same process, you know, this person has a disability. This service animal meets the definition of service animal under the ADA, and therefore the place of public accommodation should allow that animal to be there. So, I mean, it is a widespread problem, but, you know, whatever solution is created, whether it be at a, you know, business owner's standpoint or legislative standpoint, I think everybody needs to make sure that they're not limiting the very needed right of the person with a disability to allow them to utilize that animal is very much needed for their disability.
And I just want to mention, because I'm not sure most people know, the Indiana Civil Rights Law actually has legislation regarding emotional support animals. It's actually found not in our Fair Housing Act, but in our Indiana Civil Rights Law. And the state of Indiana actually does make it a Class A infraction to misrepresent an emotional support animal. We're only of like one of maybe 9 states in the country that actually does that. It kind of keeps us from being substantially equivalent with federal legislation. But I think that is an attempt to keep those provisions from being abused, perhaps. But I think people should understand that if an individual, as Tom mentioned, has been prescribed the use of an emotional support animal, or if they actually have a service animal, which is different from an emotional support animal, that again, that is the same thing as a reasonable accommodated need. And so when they make that request or show that that need is there based on a disability, that goes through that same kind of analysis. And if a housing provider is not taking that request seriously because they're afraid that someone is misrepresenting, that could be problematic. The better thing to do, instead of trying not to be duped, is to simply go through the correct analysis that you're supposed to go through, to have those conversations, go through that reasonable accommodation analysis to kind of cover your decision making. Because again, there's some legislation, it's a Class A infraction to misrepresent an emotional support animal. But again, you know, when it comes to a disability request, we tell housing providers it's their responsibility not to see, you know, if someone's trying to deceive you, but to see if that accommodation request is reasonable. And if it does not create either an undue burden financially or administratively, then it more than likely will be found reasonable to grant it.
That's a key distinction to make. Thank you for bringing that up. That actually brings us to the end of our formal program, but we still have some questions that our viewers have asked. So with our final 15 minutes or so here, I'd love to ask the panel a couple of these questions. First one is, when asking for an accommodation, does it have to be verbal or written? Tammy, I think I'd love for you to get us started on this, because I think with all of the, like I said, the breadth of resources that you make available to people who are needing, you know, various services to kind of move through the world, I think that this is a question that you've probably been asked.
I have a couple of times, and again, we tackle this in a practical manner. So asking for the accommodation on the part of the person with a disability is sufficient. The response, as I tell anyone who's an employer, should always be in writing, and you cannot add an additional burden to someone to force them to do that. Having said all of that, often there are procedures in a landlord's policy. There's a form that they wish to be filled out. From a practical standpoint, if the form is simple, easy, and the consumer is willing to complete it, we work with them if they want that guidance to help them. So as an employer, I only have to be asked. The individual simply has to ask for the accommodation and does not have to submit anything in writing. Again, accommodation can be intimidating on both sides, from the side of the person being asked to provide it and the viewpoint of the person asking. And I put in the chat that people with disabilities are often very much afraid to ask for things. They understand there's a law, they understand they have rights, and they're still afraid. If you spent 5 years finding an affordable, accessible unit, you don't want to make waves, is often the viewpoint of that person, and we want to respect that feeling. And so we sometimes will be a little more flexible than if you're a lawyer looking at this. So I would actually like Tom and Tracy to make the official announcement of that. But from my viewpoint, you just have to ask.
Sure, sure. Thank you. Tom or Tracy?
Yeah.
And our fair housing, oh, go ahead, Tom.
No, go ahead, Tracy. No.
Well, I was going to say our Fair Housing Act does not require that request is made in writing. HUD guidance kind of provides that that's a good thing to do, because it's good to be able to have documentation of the process and your participation in the process. The issue is engaging in that conversation. You don't want to unreasonably delay or avoid the conversation. That can be deemed a denial. So it's a good idea for, I believe, both sides, but it's not required under the law to make a finding that a reasonable accommodation request was made. It's not even required to use the reasonable accommodation. There's some analysis that goes to whether or not the disability can be seen, as to whether there's an understanding on the part of the provider that this is what is needed. If it has been communicated either by that individual or an advocate of the individual, perhaps a parent, a child, the courts are going to do an analysis as to whether or not there was some responsibility or onus on that housing provider. And we really get into doing conversations and having conversations more than likely when it's not 100% clear what the disabling condition, not necessarily the disability, but the disabling condition is that needs to have that accommodation to make a determination as to whether or not that request is reasonable.
Thank you. Tom, did you have something to add?
Yeah, just real quick, I was going to mention that the magic language absolutely does not need to be. So I'm glad Tracy mentioned that. You know, people don't necessarily know. You don't need to say, I am making a reasonable accommodation request in the Fair Housing Act. It just needs to be made in a manner that a reasonable person would understand that a request is being made.
Great, great. So we don't have to be lawyers in order to make this request.
But I will note that from a lawyer standpoint, while it does not need to be in writing, it is helpful to be in writing, because then you know for sure when it was made and you have documentation of the actual request.
Sure, sure. That's great. Thank you. Thank you. We have one more question here. Can landlords require doctor's letters or statements to verify one's disability? I think I will start with the lawyer. Tracy, is this something that housing providers can require?
What HUD states is there are many ways to establish a disabling condition. So the analysis again in the court would be whether or not, number one, it would have been reasonable for a housing provider to know that there was an individual with a disabling condition, and if it's visible and very obvious, that obviously it becomes less and less necessary. It is not the only way to establish that there is a disabling condition that needs a reasonable accommodation. So that's my lawyer's answer.
Okay, so it sounds like it's not necessarily is the answer. Anyone else have any thoughts to share?
As a person with an invisible disability, and this is where advocacy, the role of self-advocacy. If I needed an accommodation, I recognize that it may not be obvious to the person I'm requesting it from. And again, many times, Tom and Tracy have talked about the dialogue, that this communication. And part of what we do at Accessibility is help our consumer, the person with a disability, be comfortable with that dialogue and be coming into that dialogue with the information they need. And that is really the important part, that it's a conversation. No one has to disclose more than they are comfortable disclosing. And we often talk with an individual about what they're willing to do. I mean, you can get into particulars and we don't need to do that here. I always like to make it a question of timeliness. How soon do you need this? Is this an immediate need? Is this something that we have time? For example, someone knowing they're going to have some planned surgery and they may have a temporary or long-term issue after that. There may be more space to have more conversation. And then there's also the temporary versus permanent discussion issues. So the dialogue part and getting people to ask uncomfortable questions and be okay with a little bit of ambivalence on the part of property owners. I often try to give them the opportunity to ask their questions the way they would like to ask them. And sometimes, especially the smaller property developers, they're uncomfortable asking what they think may be a non-politically correct or not properly phrased question. And
Sure.
I would rather they ask it in their language, and then I have the opportunity to give them an answer and then help them see here are other ways to discuss that or other ways to think about that. But again, if people walk away with nothing else from this time, dialogue is the key. Agency to agency, people to people, landlord to tenant. And we need to make sure that we keep those lines of communication open as much as possible.
That's great. Yeah, that is so important that you're talking about how best to curate these conversations. It almost sounds like, even though you can be talking about agencies and organizations and property management companies or things like that, but it does sound like you're talking about giving some ground rules to have this conversation and community building. And if you have an environment of community, then people can, maybe their comfort level goes up and these discussions become more effective.
Absolutely. And knowing who is the right person. So if I have a consumer with a legal issue, I call Tom or Bonnie at IDR, because we are not attorneys. And there's an empowering thing that happens to a person with a disability when another person with a disability says, I don't know, let's find our subject matter expert. And that's why these open conversations where we look at how we look at it differently, that viewpoint is important. And so that's why this kind of conversation and these kinds of presentations are so important. I often don't know all the things another agency is doing. How can I expect them to know all that we do?
Certainly, absolutely, absolutely. We just have a few more minutes. I did just get one more question in our Q&A here. We're going to go back really quick to the idea of service animals, or excuse me, emotional support animals. So what qualifies an animal as an emotional support animal versus a pet? And is a doctor's statement needed for that to substantiate it?
So go ahead. Looks like you're about to go.
No, you can go ahead. That's fine.
Yeah, I mean, I think it go back to, like, you know, unfortunately, HUD hasn't given us a specific definition. They've provided some guidance that basically says that if an animal provides emotional support that alleviates one or more identified symptoms or effects of the disability, then they would qualify. The easiest way to provide that and show that is a doctor's note or a service provider note of some point. So it's not necessarily stated that it is required, but it is absolutely the easiest way. So Tracy mentioned kind of a prescribed animal earlier. It doesn't need to be kind of to that extent, but it can absolutely be just a letter saying, you know, I'm treating so-and-so, they have this disability, and this animal would alleviate, you know, X, Y, Z. And I think that's enough. So while it may not be required, you know, multiple sources can be provided to kind of justify the need, reliable third party, doctor's notes, etc. So it doesn't necessarily need to be a treating physician's doctor's note, but something like that can be often needed to show that this is an animal that alleviates one or more symptoms.
Thank you for that. We have 3 minutes left, and I did just get another question. So I don't want to be too abrupt, but I did want to try to get this in. Is a landlord allowed to ask what your disability is if you have an invisible disability, quote unquote, invisible disability?
The issue is not the disability. It's not so much the question of whether the landlord is required or allowed to ask. Is the tenant required to disclose their disability, and that tenant is not required to disclose their disability when they're engaging in these conversations to clarify whether or not the accommodation request is reasonable. They disclose their disabling condition. So what it is that needs assistance or help with so that they can use and enjoy housing. I use the example, you don't have to say I have lupus. You could say I struggle with some certain issues of exhaustion, or so I may need to have a parking space closer to my unit because by the end of the day I could barely get out of my car and walk. I mean, that's kind of an extreme example, but it's more the disabling condition that needs the accommodation, as opposed to having to say like what you've exactly been diagnosed with. You don't have to say I've been diagnosed as bipolar, but you can say I've been shown to have the need of an emotional support animal to assist me with day-to-day living, that type of thing. So it's not so much the disability as it is a conversation about the condition that needs, that has the nexus to that need for the accommodation.
Understood. Thank you. Actually, if all of our speakers wouldn't mind entering their contact info in the chat. This has been a wonderful discussion, but I still think that there are some questions rolling in that we may not be able to get to today. So it would be wonderful if people have the opportunity, if you're able to reach out to you. So if you could have that information, that would be wonderful. It looks like real quick at our last minute here, I might have one more. Online, you see all these companies advertising service animal registration for a fee. Are service animals required to be registered? I don't know if we quite covered that nuance.
Unequivocally, no.
Okay. Okay, quick and easy. That was a good question for our final 60 seconds. Unequivocally, no. That's great. All right, wonderful, wonderful. And I hate to cut this really robust discussion short, but unfortunately we have reached our time. So if everyone could reach out, if we didn't get to your question today, if you could reach out to our speakers, we'll do our best to connect with you as well and get those follow-up answers to you. Again, thank you so much to all my panelists. This was, again, a really robust conversation. It sounds like the overarching themes that we have are the need for that education and awareness, but also that empowerment And again, that building community so that these really important conversations can happen. So hopefully today we advance those efforts just a little bit. So I want to thank you all for joining us today and enjoy the rest of your afternoon.
Thank you.